The judgment of this court penned by me is unanimous. It is concurred in by Maya C.J., Majid J., Matopo J., Shantla J., Rogers J., Sigobin A.J., Theron J., and Chikri J. This court has agonized over Vodacom's submission about a court's disregard of facts giving rise to a total failure of justice. How flawed must an assessment be for it to cross the line to constitute a failure of justice and thus a violation of the rule of law and the right to a fair hearing guaranteed in Section 34 of the Constitution? Put differently, what is the threshold above which our constitutional jurisdiction is engaged? In what circumstances does the assessment fall short of that threshold so as to be hit by the Busak or Mbata principle to the effect that dissatisfaction with a court's assessment of facts does not engage our jurisdiction? On the face of it, Vodacom's argument seems to take us to a slippery slope that will result in the reach of the Busak and Mbata principle being difficult, if not impossible, to implement. Will that principle not be unacceptably attenuated? Whatever the attendant difficulties, is the real question not whether there has been a total failure of justice? In this context, I am not concerned with esoteric debates about what justice is. I am concerned with justice in the sense of a reasonable expectation that within the bounds of human fallibility, courts will do what is expected of them. Justice and indeed the court process are not about perfection. Courts are not to be held to some abstract standard of perfection. It is unsurprising that in the case of Bennett, this court held that judicial officers are not superhuman beings who do not make mistakes. This is why there is an appellate process to correct mistaken findings on law or facts.